This is the Board of Chiropractic Examiners. This Government and Public Affairs Committee meeting is being held by teleconference under the Governor's Executive Order number 29-20. The date is April 13th, 2021, and the time is approximately 2 p.m. Some instructions for public participants. The members of the public that are listening and would like to provide public comments by telephone will be limited to 3 minutes unless, at the discretion of the board, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. The Chiropractic Board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, and enforcement in chiropractic care. Please be aware that this meeting is being audio recorded. Please turn off or silence all cell phones. We will now take the roll call of the committee. Mr. Sweet, would you please call the roll?
Good afternoon. This is Raphael Sweet. Is Frank Rufino in attendance? Yes.
Present.
Raphael Sweet, present.
Great. Everyone is in attendance. And we do have a quorum, and so we'll continue with first if we have any public comments for items not on the agenda. Moderator, is there anybody on the queue that would like to make a public comment from the public?
This is the moderator. I have opened the Q&A panel. If you would like to make a public comment, please click on the Q&A icon on your screen, type "I would like to make a comment" into the text field, and submit that to all panelists. And we will pause for just a brief moment to allow time for requests to come in. Seeing no requests, would you like me to close the panel?
Please do.
It is closed.
Great, thank you, moderator. Our next item on the agenda is the approval of numerous meeting minutes. The first one is of May 21st, 2018. And I have a question for council before we take action on this particular minutes. And the question is, council, neither of I or Mr. Sweet were present during that meeting. Can we still vote, or can we just accept them as they are without a formal vote?
Thank you, Mr. Rufino. This is Michael Canocher, legal counsel. And I, as members of the board and members of the committee, you're entitled to vote however you'd like on any motion. And but you know, certainly to be accepted, the minutes would need a motion by the committee, and for that motion to pass. I thought of this as well as I was looking at the agenda, and the other option might be to move to have the full board approve the minutes, but certainly the two current members are entitled to vote on the motion to accept the minutes.
Okay, thank you for that, Mr. Knutz. I got a follow-up question. Do we need to approve them each one on its own, or can we have a motion to approve all three of them?
Sorry for the pause there. I was looking to the agenda. They are all agended under one item, so I think that would be in order.
Okay.
Either would be in order.
All right, well, before we ask for a motion, let me ask Mr. Sweet if he has any questions on the minutes.
I don't have any questions at this time. Obviously, with the caveat that, as you mentioned, I wasn't present for any of these meetings, but so no specific questions.
Okay. Well,
Michael.
Yeah, go ahead.
Sorry, Frank.
Go ahead, Ms. Palayo.
I just wanted to clarify for the comfort of the two members of this committee, them voting to accept or approve these minutes isn't them testifying as to the accuracy of them, is it? I mean, they're just accepting the minutes that were presented from the prior meetings. I don't think there's any expectation that they're endorsing or approving the accuracy of them. Is that correct? That question was directed to you, Michael. Sorry.
Yeah, I was going to say I agree with that. But in order to provide the minutes for the meetings, I think they do need to be adopted by the committee. But it's approving the minutes as prepared by board staff, not exactly attesting that you were there or heard every or heard the matters discussed.
Okay, well, thank you, Counselor, for that, and Mr. Palayo for the clarification. I'm going to begin by making a motion to approve the meeting minutes of May 21st, 2018. I'm going to separate the three. So starting with May 1st, do I have a second to that motion?
Clarification, Mr. Rufino, it's May 21st. You said May 1st.
Oh, sorry. Yes, May 21st. Thank you.
Mm-hmm.
I will second that motion.
Thank you, Mr. Sweet. We're going to go ahead and call for the vote. I will abstain, Mr. Sweet.
I'll vote to approve.
Okay, great.
I wasn't fast enough there, but on motions, we will need to accept public comment for each of the motions.
Okay.
My apologies for not getting in there quickly enough.
No problem. Moderator, can we see if there's any public comments on the approval of meeting minutes of May 21st, 2018?
Absolutely. This is the moderator, and if you'd like to make a public comment on this set of minutes, please click on the Q&A icon on your screen, type "I would like to make a comment" into the text field, and submit that to all panelists. Seeing no requests, I will close the panel.
Great. Thank you, moderator. Next is the approval of minutes of the March 26, 2019, as well as the August 27, 2019. Do I hear a motion?
I'll move to approve the minutes of March 26, 2019 and August 27, 2019.
I'll second that motion. So all in favor say aye.
Mr. Chair, we do need to take public comment again if there's no discussion from members. My apologies again.
No, Mr. Counsel, you got me again. You're absolutely right. Before we take a vote, moderator, please open the queue for any public comments on the meeting minutes of March 26 and August 27, 2019.
And this is the moderator, and the Q&A panel is open for requests for public comment on this set of minutes. Again, if you'd like to make a comment, please click on the Q&A icon on your screen, type "I would like to make a comment" into the text field, and submit that to all panelists. And seeing no requests, I will close the panel.
Thank you, moderator. Now we will take a vote. Mr. Sweet
Aye.
and Frank Ruffino, aye. Motion carries. Moving into the next item on the agenda, and that's a review, a discussion, and possible action regarding the board member administrative procedure manual. And I will ask that our executive officer, Mr. Paleo, will walk us through the manual with any comments and or questions. Mr. Paleo.
Thank you, Mr. Ruffino. Okay, well, I've gone through and reviewed and identified areas that either need to be updated or the committee needs to consider. So let me get back to the beginning of the document here. Okay, so of course, there's once we finalize this, we'll need to update the revised date on the front page. And we'll be updating it to include the names of the current board members. Those are on page 2. And just want to clarify that while we're amending this, the contents, the pages will be moved around. So we'll fix all that on the back end. So going on to page 5, we have State of California acronyms and just a couple of minor things. We for B&P, we say B&P and then Business and Professions Code. But in looking through the document, I noticed that we say B&P code. So I think we can delete code there. That's just a technical thing. And for Department of Insurance, we never mentioned Department of Insurance in this document, and it's not an acronym we frequently use, like DAG or Office of Attorney General or something. So I think we can just eliminate the reference to Department of Insurance. On page 6, I just wanted to, in the first paragraph there, make some, if it's okay with the members, if there's things that are purely style or technical, I'll just pass over those, or did you want me to go through each one of those with you?
I think from my perspective, you can pass them over. We review it, but I will ask Mr. Sweet if he's got a, what's your pleasure, Mr. Sweet?
No, I'm happy to move forward without going over the stylistic changes.
Okay,
Perfect.
great.
Thank you.
So still on page 6, the third bullet where it says board members shall not speak or act without pre-authorization from the chair and or EO. Then in the second sentence, we say, when possible, the board chair in consultation with the vice chair shall determine which board members. I would just add in there and the EO because I think between the three of them, because the EO, myself or whoever, maybe the EO, will likely have some perspective on who may have the knowledge to speak on that. So I'm just proposing adding in EO in that. I'll just keep going, and if you can jump in if you have questions or comments. So style. There on the last on page 6, the last bullet, board members should avoid discussion of confidential board business. The last sentence says all consumers, applicants, and licensees with enforcement-related questions, concerns, or complaints should be referred to the EO or chair. I propose taking out chair simply because the chair is one of the board members, and so when you have applicants or people who shouldn't be communicating with board members, they shouldn't be directed to the chair. They should just be directed to me, and if it's something that needs to be elevated to the chair, then I can do that. So
So let me ask you, Mr. Paleo, sorry for interrupting you real quick.
That's fine.
Should we maybe pause for a second to see if we have any questions as board members? And if not, that way at the end, do we need a motion at the end to adopt your changes?
Yeah, I think at the end you could just vote to adopt the changes. If there, as we're going through, if there's any that you have comments or concerns, then we can discuss those and possibly clarify it here, and then we can approve it as discussed, or we can, if we don't resolve it here, then it's something that ultimately this is going to go to the full board, and then the full board can determine whether they want to make that change or what changes they want to make.
Okay, fair enough. Let me just quickly ask my fellow board member, Mr. Sweet, as of now, do you have any concerns or questions on the proposed changes?
Not to this point, no.
Okay, perfect. Well, then let's go ahead and continue, Mr. Paleo, with your, because I review most of it and they're mostly stylistic.
Yeah.
And if there is something, if there's something of substance, we will pause just to make sure that we don't have a question, and that way at the end, then we can just have one motion that captures all the changes that you outlined in the in the proposed form that you send us, that we received via email.
Okay.
Go ahead and
Okay.
continue.
Okay, great. So on page 8, under role of board officers, board chair, it says approves board meeting agendas, and I think it should say in consultation with the vice chair and EO. And the only reason I'm making that change is because if you look at under vice chair, it says coordinates, or no, wait, somewhere in there. Sorry, I didn't highlight that. But it's agendas. Why is that? It was a consistency thing. And now I'm not seeing it. But that's the oh, it's under. I think I got that wrong there. I apologize. I'm stumbling over myself here. It's the approval of agendas is that should say in consultation with the secretary and EO, and then if you look down under secretary, in consultation with the chair and EO approves board meeting agendas. So I just wanted those to be consistent for secretary and for chair. So that's not really a change. I just wanted to clarify that. But I do need to fix this to say in consultation with the secretary and EO. Okay, sorry about that. Okay, moving on. Let's see. Under vice chair, I highlighted the coordinates the EO annual evaluation simply because the department has a new process for that and for EO evaluations, and I wanted to reference that. I wasn't able to find the memo, and I don't know. Mr. Knotes, do you know, does the department have a policy on that, or is that final yet? Because I was looking on the intranet page and I couldn't find it, but I wanted to reference that here, that the vice chair, in coordination with DCA's HR office and in accordance with the department's policy, would conduct the evaluation.
Yes, Mr. Pulley, I believe there is there's at least a form for the evaluation itself, if not a memo sort of explaining how that form is used. So I think that's in order.
Okay, yeah. So I'll get those before the board meeting. I'll get those documents and update this to reflect the departmental policy or procedure. So, okay. So we have board meetings and offices, and then down below we have where is that? Should have identified the page. Sorry, I'm trying to do this on electronically, and it's easier for me to flip through paper. But we have, oh, it's right below it. I'm sorry, I looked right over it. So yeah, so I don't know why we don't combine these two sections. So that's just a style thing, but I'm going to propose combining these rather than have multiple sections addressing similar things and overlapping. So let's see. So agenda items, the board secretarial will work with the EO to finalize the agenda. We already up above under secretary and board chair specify that they will work in consultation with the EO to finalize the agenda. So I don't see the need for this here. So I was proposing we just take that out, or either that or make it consistent with the above provisions. So okay, this is another one. I'm sorry, going on to page 11, Bagley-Keene Open Meeting Act. We address this under other headings. We reference Bagley-Keene throughout this document, and maybe if we just want to emphasize that for board members, we could leave it in, but I'd like to make the document as succinct as possible, so it just doesn't seem like it's necessary. And this also isn't a board policy, it's state law. So I was going to remove this here. Feel free to jump in. I'm just going to keep moving on unless I hear otherwise. Let's see. So record of meetings. We identified this as a board policy. This is on page 12, towards the bottom of the page. Records of meeting, we say all original video and audio recordings are to be maintained and archived indefinitely and never destroyed. I need to research that, but we do have a records retention policy, and I need to pull that up. I didn't have time before this meeting, and see if that is that's consistent with our records retention policy to maintain these indefinitely. But I don't know that we need to address this here, since it's a procedure for all state offices to have retention policies and so on. So with this section, and I would ask Mr. Knotes if this is necessary for us to interject our own board policy when this is something that we have to comply with regardless.
Certainly you can have a policy on this, but I think you're right that it should be consistent with your records retention schedule. Okay,
so we will double check this with our and compare it with our schedule.
I just have a quick question. It may not necessarily deal with this. It deals with the record retention schedule. I know you mentioned that you're going to take a look at the record retention schedule to see what whether in fact the schedule is asking for the minutes to be kept for 27 years. My question is, do you happen to know, do we, first of all, twofold, is the chiropractic board has a record retention schedule of its own? And does DCA has a different record retention schedule, or is there one to serve all the boards and all the department?
No, the department and each individual board have their own record retention schedules. We do prepare, we coordinate with the Department of Consumer Affairs and consult with the department in developing our records retention schedule. So so it's not done in a vacuum for each board. We are doing it in conjunction with the department, but we do have a separate schedule.
And was that the last time that we reviewed it as a chiropractic board? Do you happen to know? And if you don't need, I don't need the answer today, but I would like to know, maybe at the board meeting, whether or not when was the last time that we reviewed our retention schedule and approved it? And who
Yeah,
was
to be honest, I don't know if that's more of a, from my experience, more of an administrative process, and it's not something, I'm not aware of it ever going to the board for approval. So that's something we'll research all of that, and I'll work with Michael and with staff here who maintains the records retention schedule, because I believe they're in the process of going through that right now, and so we'll provide more information at the board meeting regarding records retention.
Okay, perfect. Thank you.
You're welcome.
Go ahead and continue, please.
Okay. So yeah, this is related under recording. It seems redundant in recording. We have recording of meetings and then recording, and the meeting may be audio and video recorded, but it says the board may place, because it says maybe audio and video recorded by the public, but then in the last paragraph it says the board may place audio and video recorded public board meetings on its website. I don't think it would be appropriate. We've never done this, and I don't think it would be appropriate for us to place a video that was recorded by the public on our website. And we do, because we do audio and video record our board meetings, and when we do post the videos of board meetings on our website. So it just seems like this is kind of muddled here between these two headings: record of meetings and then recording. So I want to do a little research into that and figure out what is appropriate and what the law requires. So because I don't think up until recently, I don't think the law, and I don't think it does yet either, requires meetings to be video recorded, but that's becoming the norm. I believe all DCA boards do record their videos and do post them on their website. So so I will work with staff and legal counsel to figure out what's the appropriate way to handle recording of meetings.
Yeah, Mr. Foley, if I may make a quick comment, since you're working on that, and although I have not experienced in my 8 years of sitting on this board, we have never had a minor that has come before the board to provide testimony or commentary. But there's always going to be firsts at some point, and since you're looking at that, you may want to look at that, because there's some issues with respect to a minor testifying and being in public space. Just a thought, for if you think that's worth to make a comment on that, or to address that issue if it ever occurs.
Okay, yeah, that's an interesting question. I've never encountered that, but it could happen, and I don't know if there would be issues with recording that or posting it online. So so we'll look into that as well. So moving on. So on page 15, travel arrangements. I as a reference, I included in the meeting materials the DCA Travel Guide, and so that's really, those are the rules we have to, board members and civil servants all have to abide by, the rules that are, the state rules and state administrative procedure manual and so on for travel. And so that's our guiding document, and so I think we should reference that here for board members. That so, and that is a document we provide to the board members, and so you just wanted that to be referenced here, that it's not just a quick paragraph about what what the travel arrangements requirements are. So on page 19, committee appointments. I had a little bit of concern with that paragraph in the middle. It says committee members shall appoint the chair of their respective committee. If a disagreement arises, the committee members shall consult with the board chair, the vice chair, and the EO. So, I mean, you're potentially bringing 4 different board members into a discussion, and I don't know, since it's more of a technical matter, Michael, would that be something that would be appropriate, or should we not have all these board members communicating about this matter?
Mr. Polillo, yeah, I agree that without some clarification here, that this could lead some board members astray into potentially having a meeting or having a serial meeting outside of Bagley-Keene. Certainly, if the committee wants to keep a statement like this, we may want to add to it by placing the matter on the next agenda for the regular meeting. There may be a consultation, or perhaps just eliminating the sentence, because when it comes down to it, I mean, committee assignments are determined by the chair.
Yeah. And then as far as we don't have a procedure, and maybe that's what we need to do, is develop a procedure for since the committee members select their own chair, we may want to add a section on the selection of a committee chair. We're generally talking 2 or at most 3 members on a committee, and so we've never had a disagreement previously, but it could happen, and so I don't know what how the board would like to handle that. So that's this committee has suggestions.
Well, my suggestion, or my 2 cents, is I tend to agree with council to take this totally out. I don't think it's necessary. It adds sort of some confusion with the real process. And the real process is that, or at least the practice that I have witnessed in the past 8 years, is that typically the chair, in consultation with the vice chair, the EO, they typically identify who serves as the chair. So I think to state otherwise, I think it will be confusing. So that's why I'm proposing to eliminate that sentence.
Okay.
So I'm not sure, Mr. Sweet, do you have a?
No, I agree with that. I think if there's already a mechanism in place for the board to, or excuse me, for the chair to make the determination, then adding anything else would be confusing. I mean, it says right above that the chair does it in consultation with the vice chair and the EO. So, the chair can consult with other people, but it sounds like the ultimate decision is with the chair, and to add something else would confuse the matter.
Yeah, and that's how it always had been. The chair would appoint the committee members and also identify who the chair of the committee would be. But a couple of years ago, the board changed it to allow the committees to select their own chair. Although I'm seeing that it's leading to some confusion, and there is no procedure for it. So, and unless any of the board members object, I think it would be advisable to go back to just having the chair of the board identify who, in addition to appointing the committee members, identifying who the chair of that committee would be.
I concur with that recommendation, Ms. Palaio.
Okay. Let's see.
And it sounds like I don't want to take for granted, Mr. Sweet, are you
I concur as well. Yes, thank you. Thank you for checking.
perfect? Of course. Okay, so there we go then. We giving you direction, Mr. Palaio, on that one.
Okay, thanks. Just a second, let me write a note here. Okay, let's see. I have on page 19, it begins on page 19, Government and Public Affairs Committee. And then at the very end, going on to page 20, says the committee shall report progress. Well, it says must, and I changed that to shall because must seemed a little extreme. But shall report progress on the strategic plan annually beginning in 2013. And I don't know the need to reference 2013. It's just an ongoing process. But I need a point. I have a point of clarification here, or I'm asking this committee. So, do we want the committee to provide updates at every board meeting, or only annually at board meetings? So, because right now it says the committee shall report progress on the strategic plan annually, but it doesn't say to whom. And so I'm assuming it's to the board. And so what would be the preferred frequency of reporting updates?
I believe, and this is just I'm thinking out loud, and of course, but I believe it's not necessary to report on the strategic plan at every board meeting, but it is appropriate and necessary to report annually, once a year, perhaps at a predetermined, maybe the first board meeting of the year, or if we want to specify, but I would not even go that far. I would just say that annually the committee reviews and reports a progress report to the entire board. That would be my initial reaction. Mr. Sweet, do you have a?
No, that's my initial reaction as well, except I don't know if there would be, and again, being relatively new to this, I don't know if there would be a requirement or some necessity to report, like add some clause just saying, or as, an issue arises that might prompt us to want to report something to the board regarding that strategic plan. But I don't know if that's something that could come up.
I think you're correct. Past practice had been that every time, right now we don't have, our last strategic plan recently expired, and we need to do a new strategic plan. But past practice had been that every time the Government Affairs Committee met, they would discuss the strategic plan. And there's other committees, like the Enforcement Committee, may have responsibility for certain items in the strategic plan. And so staff would provide updates on the progress to this committee, and then this committee would report at board meetings. So, I think it would probably be, when we have an active strategic plan, it would probably be appropriate for that to be on the agenda for every government affairs meeting. And then we could say the committee shall report to the board at least once annually, or as necessary. So leave it open, but at least once a year.
Yeah, I think that's a good idea. Annually or as necessary.
Okay. So we'll update this and then present that at the board meeting.
Yep. Mr. Sweet, are you?
Yes.
You on board with it?
Yes, that sounds
Perfect.
good.
Excellent. Thank you.
Okay. So on page 22, all correspondence, press releases, articles, memoranda, blah, 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 must be approved by the board chair and EO. The EO will reproduce and distribute the document. They left out a word there, but it should, and save a copy in a chronological file. So I assume that, you know, the intent, I don't know when this provision was put in, but the intent was to distribute the document to all of the other board members, or all of the board members, but I just wanted to clarify that with the committee and ultimately the board. Is that is that what the board would desire, is to have all of these things reproduced and distributed to the board members?
Yes, from my perspective, Mr. Vallejo, I think he should be distributed to the whole board members. I think it would be appropriate and necessary, actually, to keep everybody on the same page. That's my thinking.
Yeah, I have no preference one way or the other, so that's fine with me.
Okay. Okay. The next subject: request to access licensee or applicant records. It says, this is board policy: board members shall not access a licensee's or applicant's file without the EO's knowledge and approval. Records or copies of records shall not be removed from the board's office at any time. Michael, I have a question about this. What information is a board member entitled to? I mean, because a lot of the information in a licensee's file would be public information, and certainly if a board member requested that information, we could share it with them. But if it's not public information, is a board member entitled to access a file and have an unrestricted view of it?
Yeah, Mr. Polio, that's an interesting comment, and I think I missed this as I went through. I'll have to get back to you on that. There may be circumstances when that would be appropriate, but generally the enforcement and other duties are delegated to the executive officer. And should a board member, I think that perhaps that's just something that wouldn't be advised, right? Because if a board member saw something in the file and then discipline or another matter with relating to the doctor came before the board, that board member would have to recuse him or herself from the decision. So,
yeah, I
frankly,
can see
I
it
think
being problematic. It's never happened.
Yes.
But since we're addressing it in here, I just don't want to have a document that says, that the board member can access the file, and it seems like that would be prone to issues.
Frankly, I'm happy to research this more and get back to you, but that's my take, just in terms of that issue, in terms of needing to recuse oneself if there's a disciplinary matter. I'd advise you just to take this paragraph out. It seems to me like it may be a dated piece of your manual here.
Okay. So do the committee members want this provision stricken?
And can I answer the question? Is it because it's talking about records being removed from the office? I mean, it sounds, to council's point, I think, is this contemplating electronic records? Can't tell.
Yeah. This was, I don't know how far back this dates. So it seems to be talking about like a paper file, like the board member would come to the office and look at, we'd open up a paper file for them to view, which
Right.
wouldn't be necessary anymore. And certainly any public information, a board member, like any other member of the public, could request that information, and a lot of it's online anyways. But if we're talking about confidential information, my ultimate question is, should that be shared under any circumstances? But yeah, I think the reference to removing something from the office is antiquated.
You know, and Mr. Pulio, just thinking about this from the perspective of being written before the information age, this may have been necessary to allow board members to view documents for disciplinary cases and preparation for disciplinary cases. And I'm just thinking at this point that this section isn't necessary. So that's my additional 2 cents there.
Okay,
By
I'll defer to the committee.
Well, I'm not disagreeing with what's been said, but I am reflecting on a little bit. And I'm trying to envision, even though in my, again, during my tenure with the board, I don't recall having an issue with a board member requesting access. But there's always going to be that first time. There's always going to be that one time where a board member or even a officer of the board will make an argument. Of course, I should have access. Blah 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 blah. And so I am trying to reconcile the need versus confusion. And what I would, if we were to keep it, I would strike the second part of the sentence, but I would add one qualifier that the applicant's file without the EO's knowledge and legal approval. I would add legal approval. I would wanted to make sure, that legal concur, or there was no an issue that potentially could come back later to bite us. If we were to keep it, that would be what I would do. And but I can also see the point that this might be, that could create more confusion than it solves it. So I am on the fence on this. My instinct tells me that maybe it will not harm anyone by keeping it, but I would add that legal approval on it.
Yeah, my thought is that there, at least that first sentence or something to that effect, whether we, change it slightly or not, I don't know that I feel comfortable completely removing it altogether.
So so the committee sense then, I agree with that statement. I'm not 100% comfortable removing it altogether as well. So I think strengthen it and make it a little clearer, and I leave to the experts. I leave it to legal counsel and to the executive officer to perhaps, unless Mr. Sweet, do you have any suggestions how or?
I mean, I guess my previous thought before you addressed it was that approval implied legal approval, but maybe it doesn't. I don't know.
Yeah, I mean, it sort of does. I mean, because if a board member asks me for access to a licensee's file, if I had concerns, that would be my first step, would be to consult with legal counsel. Again, it's not something that ever happened, and I question why a board member would need information that isn't publicly available on a licensee. It puts that member and the board in a precarious situation, because I would have to question if it's not related to an existing enforcement case. In enforcement cases, we provide the board members with the information that we're allowed to share with them for that case. And there's certain information that the board members aren't privy to. And then why else would a board member need confidential information about a licensee? So it just, I have concerns with this. If somebody was asking for information that, I wasn't sure I could provide, it's because I mean, a board member right now can ask for, I don't know, it gets a little dicey. I'd have to refer to legal counsel on this.
But it gives you, but to your point, Mr. Poleo, it gives you or the EOs the ability to approve it and the ability to say yes or nay in consultation with legal. If in the event that for some reason, the EO decided to make a decision on their own without consultation, I think that little consult makes it clear that you should consult legal.
Yeah.
So let me,
yeah.
oh, I'm sorry, Mr. Puleo.
No, go ahead. No, please.
So let me just jump in here briefly, and I'm reading between the lines here, of course, and I'm not sure exactly what was intended by this section, but when I look at this, the only time it's really appropriate for board members to be accessing a license or applicant's file is if there's a disciplinary matter or a potential revocation or a denial that the board needs to look at files in order to consider that matter. And so I'm wondering if this was really intended to provide that access, and perhaps in the very bygone age where there was one copy of all of this information to say that it shall not be removed from the board's office. Because if that's what we're talking about, that's not how we distribute information for disciplinary cases now. So, so both we would be potentially violating the second sentence every time we do a discipline case. And I also don't think that you want me having to approve Mr. Puleo every time you send something out to the board in terms that involves records of a licensee. I'm really thinking this section pertains to discipline. I could be wrong, but I can't think of another reason why a board member would be needing to access the non-public information that in this day and age one can get from your website.
So can we infer that you're saying this just isn't relevant anymore, this whole thing?
That's my sense of it.
Yeah. Yeah, I think this, I mean, it's maybe a non-issue, but I just think this section raises questions. And if a board member, not current board members, but in the future had less than ethical reasons for wanting to see something, and then it puts us in a situation of because this implies that board members are entitled to see a full file, a licensee's file, which, a lot of this information we don't even retain in paper anymore. So, if there was something that we were authorized to share with a board member, we would just scan it and send it to them. But yeah, it just seems like this would raise questions. All the questions that we're having right now in this meeting could come up if somebody started asking for things. And I would have to wonder, why would a board member want to see an applicant's file, somebody who's applying to be licensed? Board members shouldn't be really engaged in that. They shouldn't be influencing decisions as to who we approve. We have laws that say what the requirements are to be licensed in California. Staff receives all the information and evaluates it. If a board member has concerns about staff, then they should probably bring that to the attention of the Director of Consumer Affairs. But this just raises questions about why would a board member need to see information that wasn't publicly available already. So I don't want to withhold information from board members, but I also don't want to put the member or the board itself, the entity, in the position of violating confidentiality or providing them with information that then is going to require them to recuse themselves if the matter comes before the board.
Well, having said and having heard both Mr. Puleo and the council and the inferred that this may not be relevant, perhaps we should scrap it, take it out entirely. That way, and if we ever have that one time, we'll future board or whatever, we will deal at that time But
Yeah, I mean, this is the kind of thing.
it's reasonable. What you're saying is totally reasonable. I mean, a board member should not have a need, an ethical anyway, to review. But the larger question here, and it's a more like a rhetorical or more of a principle question, is: does a board member or the board has quote unquote authority, not the authority, or is within his or her purview to review or to view someone? And I don't know that answer.
Well, just to repeat what I probably didn't say so artfully before, the one time that board members do review applicants potentially and licensee records is in discipline cases, which is why I think you almost have to read that into this, as well as you have to be reading this in the 1970s or 1980s or perhaps the early 90s before we went to a lot of electronic records. I just think it's antiquated for that reason.
Yeah, agreed. And also we're restricted on what information is sent to the boards. Like when we send out the mail ballots for enforcement cases, we're allowed to provide the information to the board that we can provide them with the accusation, the disciplinary order, and the memo from the Attorney General's office. We're not allowed to give them other information. So then if a board member was requesting more, that's which they can do. I have had board members say, well, we don't have enough information to make a decision on this. But then that's a legal question. Then I would have to refer to DCA's legal office or to the Attorney General's office and say, am I allowed to provide them with this additional information? And the answer would likely be no. So it's, there's a process for board members requesting information, but a board member reviewing an applicant or a licensee's file, which is an outdated term, this is probably referring to a paper file. I just don't see what they would need to see. That would be appropriate for them to see.
Mr. Sweet, can you live without this, or your thoughts?
Yeah, I think that's fine. If council and Mr. Palaio think that this just isn't relevant anymore, I don't want to. What I don't want is I don't want this clause to imply that all board members have access to a licensee's file as a default. So I do think that might be a concern as they were mentioning that.
Yeah, and another thing is that the term file is vague. I mean, because we have information on licensees in our system, but we have licensing files, we have enforcement files. They're not all combined in one place. And so what exactly is this referring to? A licensee's file or an applicant's file? And so
I think, Ms. Palaio, you convinced us. So I think for clarity purpose and let's go ahead and remove this sentence.
Okay, yeah, and not to beat a dead horse, I just want to make sure you have the full picture, because this goes back to something we were discussing earlier in this document. The if a licensee contacts a board member, about their application, or an applicant who's trying to get licensed, they contact a board member, or somebody who we're investigating contacts a board member. The board member is putting themselves in a situation where they'd have to recuse themselves if they get personally involved, and so it wouldn't be advisable. And as we say there, they should refer the matter to the executive officer. And to the extent that you trust your executive officer to handle it appropriately, I think it's best that board members not get personally involved, especially licensee board members who could have a conflict if they're obtaining information about competitors or something. It just, not to say that anybody, certainly not people that are currently on the board, but if you had somebody who had less than honorable intentions, they could get themselves and the board into trouble. And so I'd rather not have something that's indicating that that would be okay. I'm done.
Okay, move on. We got consensus.
Okay, thanks. So
On page-
on page 23, under board policy, it's right at the top of the next page. Board members shall not speak or act for the board without proper pre-authorization from the chair and or EO prior to making any statement or press release. And then we go on to say, when possible, the board chair in consultation with the vice chair. And I would add in here and EO. I mean, the board chair likely would consult with me anyways, but I think it's advisable for board members to, not that they need my approval to say anything, but it's advisable for them to check in with me in case I have information that they might want to know before speaking on an issue. So it just, and also we do earlier in that paragraph, we say in consultation with the chair and or EO. So that's just, unless if somebody has objections to that, just leave that there. Okay, and then oh, here we have EO evaluation again, which I have to find that up above.
Mr. Fuller, before you, sorry
Go
to
ahead.
interrupt you, but before you leave page 23,
Uh-huh.
I have a quick question about the identification cards. So as you may recall, we talked about this previously. I think last year we were going back and forth, and we were going to check in with DCA for purpose of travel. If Mr. Sweet is in the airport and he's asking for a car rental, they're going to want to see his state badge, and he's not going to have a state badge to prove that he's a chiropractic board member. And I think we were. I don't remember if a final decision was made on whether or not we were going to issue badge. And then the second part to that is, do we need, if an officer of the board, that shall be stated. I don't necessarily think that we need that. Otherwise, every year you will be changing badges. So
Yeah,
that
that could be a nuisance, especially, I mean, to be honest right now, because we don't have professional equipment to produce badges. So unless the department, and I don't know if somebody from board relations is on this call, on this meeting, that might be able to clarify whether other boards, whether department produces badges for other board members, or because otherwise we're just going to be making something on our computer and printing it out and then laminating it perhaps, which we don't even have a laminating machine. So our ability to produce any kind of official badge is limited, and really the only circumstance where and I understand it, it's something that does happen, and if a board member is renting a car perhaps, or staying at a hotel and they're getting the state rate, which sometimes the hotel, usually they don't, but sometimes they will ask for your state ID, and a business card isn't sufficient. So so in that case you would need the state ID. But I will, thank you for bringing this up, because I'll check with the department and see if they have a policy or recommendations on this, because it's one of those things where we can produce some kind of a piece of paper that with your photo on it that says you're a board member, but it's you could actually do that yourself. So ours wouldn't be any more impressive or official than what you could print out on your own computer. So
Yes, and I agree with you, and I think DCA perhaps should be looking at this for all their boards and commissions, and maybe they can, issue something that, or maybe one of those things, that they could handle for everybody, during the board orientation, for example, or notwithstanding the fact that right now, even board orientation is done virtually, but in
Yeah, eventually
Right.
though, we'll probably return to traveling again and overnight travel perhaps. And so there may be a need. So it's one of those awkward things that I'll have to, excuse me, I'm sorry. I'll have to check with DCA and see if we can request DCA IDs for our board members and have them issue them, because again, otherwise we don't have laminating equipment or the
Yeah.
ability
No,
to
I
print
get
out stuff.
Sure, I get that. And then and ultimately, if DCA, for whatever reasons decide not to, then this particular section should be eliminated, rather than, because otherwise we cannot right now honor our own policy because we don't have the ability to do it. But more importantly, as I said, more importantly than that, and heads up to Mr. Sweet, I've had a personal situation, and I'm a state employee, so I can always provide a state ID. And even with my state ID, at one time, I had an employee, which unfortunately, whether it was having a bad day or what, they said, "Oh, no, 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 it has to be an ID of your board that you're working for because that's who's paying. That's our policy." So, so thinking ahead, maybe, and this is sort of like way thinking ahead, but perhaps DGS should get involved once a decision is made by DCA and give different instructions during their contract negotiations with these car rentals as to what type of ID, so that it would not put a member who does not have an ID at risk, like I did, where I had to argue back and forth, and I had to go to the manager and explaining to him and educating him that I'm a state employee, blah blah blah. There's no way that I could get the car. The actual reservations were made by the board staff, not by me, and so on and so forth. But anyways, just between parentheses, I wanted to share that, and maybe you could share that with DCA if they want a firsthand account testimonial, But other than that, I think even having access to the board office, a simple driver license works. But nowadays, even having access to the board office or entering the board office, they ask for your ID.
Yeah, and at one time, personal computers didn't have the ability to produce professional looking or IDs, and so I question the value of having some kind of an ID badge. So I agree with your opinion about general services should really look into this, because otherwise, what if you just print out on a piece of paper something that says that you're a board member for BCE? How's the person at the hotel going to know whether that's legit or not? But also, the department is aware of your testimony. I got a message that they're looking into it. So, so thank you.
Perfect. Okay, let's move on. Sorry for, unless Mr. Sweet, you want to?
No, I just agree with the sentiment that if it's in there and it says that they shall be issued something, then we should do it, and if we can't do it, then it shouldn't be in there. That's all.
Great, thank you. Go ahead, Mr. Polio.
Okay, and so then on page 24, executive officer evaluation. This goes back to the same discussion we had earlier about the DCA procedures, and so I want to align this with that. So prior to the board meeting, I'll update this to reference the DCA procedures. It would essentially be the same. The board vice chair would oversee this, but they would work with DCA's Human Resources Office. And then also, I need to look back, because the fact that this is mentioned in two places, I want to try to condense things, so I may refer in one place to this. The next thing, board administration on the same page. I just had a problem with the says day-to-day management of programs and staff shall be the responsibility of the EO as an instrument of the board. That just seems like an odd term. So I was proposing changing that to agent. So, unless anybody objects.
We'll make you a special agent.
I don't like being referred to as an instrument, but and then again under board staff, that same word. So if change that to agent, it seems like a more appropriate and universally understood term. So on page 25, just a periodic fee audit. Audit has connotations that usually if there's something wrong, like if there's a problem, then we get audited by the Office of the State Audit or something. And we're talking about what now they refer to as a fee analysis. So I'm just proposing changing this to periodic fee analysis, which is something we're in the process of doing right now, and just replacing the term audit. And let's see, the board shall conduct the fee analysis every 3 to 5 years using the 2017 methodology. I think that's referring to the last fee analysis that we had done, and I don't think this reference helps anybody, the 2017 methodology. So we consult, we hire a consultant, an accounting firm or consulting firm to conduct the analysis. So I think this sentence could be removed unless one of the members has thinks otherwise.
I had no objection.
So same here.
So I got the whole sentence. The board shall conduct the fee analysis every 3 to 5 years. And then I'll take out the rest of the sentence. So, then on page 26, at the top, various other tasks and responsibilities, we list liaison, board members serving as liaisons or contacts with other agencies, including FCLB, NBCE, and so on. And then at the bottom it says this process shall be overseen by the vice chair in consultation with the chair. And I'm just suggesting putting in the EO because most likely I will be involved in the coordination of these type of activities. So just adding that in there. And then towards the bottom of page 26, terms and removal of board members. No person shall serve more than, the second paragraph, no person shall serve more than 2 consecutive terms, nor be eligible for appointment. And so we say, until the expiration of 4 years from the expiration of such second consecutive term, effective January 2nd, 1974. I have no idea what the relevance of that date is, but I think we can delete that without causing any problems. And so then going on down to page 27, resignation of board members. This is a board policy, but I would think the governor's office would have a protocol or I've never, maybe it's not official or written, but because I've never seen it, but I just I'll look into this, but we may want to reference whatever the procedure for the administration is for notifying them and who we should notify, because I'll typically, if a board member notifies me that they're resigning, I would alert the department and the governor's office, but I don't know if there are protocols. So so I'll look into that and update this accordingly. and conflict of interest. This refers to Government Code Section 87100. Michael, I don't know if you had a chance to look at this, but is this all still current? This is probably several years old. I don't know if any of these procedures that we identify here need to be up.
Mr. Pulio, yes, I did take a look at it, and this is a long-standing provision of state law, and it remains accurate.
Okay, cool. Then down to page 28. Yeah, request for grants. We've never requested grants, and I don't know. There must be rules and policies related to this. And I'm not aware of any place I've ever worked that's requested grants. I know there's state agencies that issue grants, but this is, I never knew that that was even something we could do. So I guess we could just leave this, but it's not something in my more than 10 years with the board. It's not something that's ever come up.
Yeah, Mr. Pulio, I found this very interesting language too, and I'm wondering if it is from a different era when the board was independent and when there were different rules in state government on offering grants. But my read would be that if the board was going to offer a grant for any particular purpose, that would have to be either authorized in the Initiative Act or in statute. And then there are, state procedures for how grants are authorized. I would recommend removing this provision.
Okay, committee members, do you have any opinions on this?
I mean, I'd say I don't recall to actually grants. The only thing that comes to mind, but I'm not sure if it qualifies a grant, is whenever, for example, a professional association underwrite a board member travel or registration fee. I'm not sure if that could be stretched and consider a grant. Probably not. But I would say that unless DCA has a policy with respect to requests for grants that could be applied to all boards, just in case in the eventuality that there's ever, a potential for a grant, I would refer to that or just eliminate it altogether. Like I said, I don't ever recall that this board made a request for a grant. So those.
We never have. And I'm not even clear whether this is this provision is referring to the board requesting grants from other institutions or external entities requesting grants from the board, because it talks about board-specific projects and requests for funding allocations to board-specific projects and any requests for grants outside of the board's business or projects. So I don't know which way we're talking here. And again, in my tenure, I've never seen either. We've never given grants. Yeah. We don't have money to grant, and we've never requested grants from external entities.
The only time that I potentially could, and this is a stretch, but if we did a joint project with the school, for example, the board and the school undertook a specific project, XXYZ, and the school was financing that project through either a federal grant or to some sort of grant. Indirectly, the board will be benefiting from that grant, but the actual administrator of that grant, in that case, I presume will be the school, not necessarily the board. So that's a stretch. I mean, I don't recall ever have potentially,
Yeah, I'll try to look into this a little further, but unless I can find any indication that there would be opportunities for us to receive grants, I think to eliminate confusion, it'd be best to just omit this provision.
And my comment earlier, I'm reading this to be discussing the board making grants from the board special fund. And so that was the reason for my comments around that the board could not grant money from its fund for any particular purpose without
Yeah,
either a statute or authority in the Budget Act. So
yeah. And when you made your comments, it made me look at it again, because when I read this, I was thinking of it as the board requesting money, and then when you said that, I looked at it again and I thought, oh yeah, and maybe that's what it's saying. But it's a little ambiguous to me. And what's a board specific project? Because if I don't know, if because we wouldn't give money to, unless we contracted with, say, a consultant, we wouldn't give money to an organization to undertake a project of ours. So it just it leads to a lot of questions that I think this whole thing just creates confusion.
Mr. Sweet, do you have any strong feeling one way or the other? Keep it or take it out?
I don't have strong feelings one way or the other. I'll defer to you, Mr. Rufino. But if this doesn't seem applicable and we've never come across this issue in your 8 years, then I have no issue. I have no problem getting rid of it.
Okay, well, I think the committee sort of hearing the comments from both council and the EO, I think we'd probably be better off taking it out and all together, and that way we can, it makes it clear, and then if we ever need to deal with grant, we'll deal later.
Okay. So, and this will ultimately be going to the full board. So if
Sure.
If any of the board members have concerns or questions, we can look into this further.
Sure.
So, okay. So on page 29, honoraria prohibition. I'm assuming, Michael, this is all still relevant.
Yes, Mr. Pulio. The Political Reform Act of 1974 is one of those few laws that doesn't get amended much because it was an initiative statute, and it can be amended by the legislature, but with a supermajority vote. So all of this is still accurate. But most interestingly, the citation for this particular provision is wrong. So where it says section 89503, it should be 89502.
89502. Okay, corrected. Thank you. Let's see. Injury to a board member. Labor Code 4600. I don't know if because board members are, for purposes of workers' compensation, are considered state employees. So assuming if Labor Code section 4600, is that the same code that state employees would be subject to? I mean, or because it should be consistent with an injury to a board member, if it came to my attention, would be handled the same as an injury to a staff person.
Yeah, Mr. Pulio, that section is a general section where provisions regarding workers' compensation begin. I would also suggest that this section, while it may still be relevant, should be conformed to DCA's policy for reporting injuries. I'm guessing that the current way this is drafted was for when the board was its own entity. So now, similar to the travel manual, I know that there is a DCA policy on workers' compensation and how to report injuries, and this should probably reference that policy rather than providing the information it does.
Okay, I'll update this for the board meeting to reference that policy. And that's all. We're going to be under the addendums. We're going to be discussing the BCE Legislative Bill Tracking Manual, but I thought that should be referenced here, as that's part of the board member procedures, and as well as the department's travel guide. And then if we add anything else, such as the workers' compensation policies and so on, I'll add those to the addendums.
Okay, so that was a very lengthy but necessary review. Mr. Sweet, do you have any other concerns, edits, or comments about the board member administrative procedure manual?
No, not at this time.
Okay, so then, do we need a motion, or can we just by consensus say that we approve the noted changes as discussed? Do we need a motion?
If you'd like to make a recommendation to the board, that would take a motion. Otherwise, this matter can be concluded. We would need to take public comment in either case, though.
Correct. So before then, we make a motion, the moderator, well, Mr. Pulio, I just want to make sure before I go to the moderator, do you have any other comments or any other concerns?
No, just again, most of this was technical and just things that were confusing or needed to be updated, and then just style things. So to the extent that the members of this committee are comfortable with the proposed changes and with the with the updates that we discussed today, that then just a motion to that effect, and then we'll present that to the full board.
Okay, great.
And
So-
Mr. Chair, may I suggest that if otherwise we'll have to do public comment twice. If there's going to be a motion, perhaps make the motion and then move to public comment after committee comments, of course.
Okay, got it. So then I'll make the motion to adopt the changes discussed and noted.
I'll second the motion.
Okay, so before now we take a vote, is there any public comments? So I'm going to ask the moderator to please open the queue for any comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a comment, please click on the Q&A icon on your screen. Type "I would like to make a comment" into the text field and submit that to all panelists. And seeing no requests, would you like me to close the panel?
Please do.
It is closed.
Okay, so back on the original motion to approve the changes as presented. Mr. Sweet
Aye.
and Frank Ruffino, aye. So motion carries. So Mr. Pulio, you can prepare the changes and the recommendation for the next board meeting.
Okay, thank you.
Okay, so moving right along, I know time-wise we sort of a little bit behind, but that's okay. It's all good, necessary work. Our next item in the agenda is to review, discuss, and possibly take action regarding our legislative bill tracking manual. So I'm going to start off by asking Mr. Sweet if you have any questions on the tracking manual or if you have any concerns.
No concerns. I thought it was well laid out and very informative.
Okay. And any edits that you can think of?
No.
Okay. Mr. Pulio, do you have any comments before we? I believe you made some very minor. I don't think you made any.
Yes, Andrea went through and identified things that needed to be updated, but there's no substantive changes to this document. The process remains the same. We developed this not too long ago, so unless the committee has anything they want to change or update, we can just adopt it. Or I mean, approve it as is.
So we need a motion.
I can make a motion to approve the legislative bill tracking manual.
And I'll second that motion. And before we vote on it, moderator, could you please open the queue for any public comments on the legislative bill tracking manual?
This is the moderator. We've again opened the Q&A panel. If you'd like to make a public comment, please click on the Q&A icon on your screen. Type, "I would like to make a comment" into the Ask field and submit that to all panelists. Seeing no requests, would you like me to close the panel?
Please do.
It is closed.
Okay, so back on the motion to approve the legislative bill tracking manual. Mr. Sweet,
Aye.
Frank Ruffino, aye. Motion carries. So we are now moving into agenda item number 6, which is a review and discussion of possible action regarding AB 29, which deals with state agencies meetings specifically. Before we start the discussion, I have a question for council or for the EO possibly. I would like for us to take a look at an additional bill that it's not listed in these bills. Is that something that we can do, or do we need to agendize for the next meeting or for the board meeting?
You can certainly mention the bill that you'd like, but we would be limited to, the discussion would be limited to whether to put it on the agenda for the next meeting.
Okay, perfect. So at the end, then I will add a new bill. I would suggest a new bill for us to take a look at it, and I'll make a comment on that when we do that. So back on the agenda, starting with AB 29, I'm going to ask staff to give us a quick analysis. And that will be Andrea or Mr. Pulio?
It will be me. Good afternoon, everyone. So I'd like to know that AB 29 has been authorized or authored by Assemblymember Cooper. This bill has passed out of the Assembly Committee on Governmental Organizations, and it's currently in the Appropriations pending hearing. The bill would require a public meeting notice to include all materials, and the materials would have to be posted to our website on the same day the materials are provided to board members, or at least 72 hours prior to the meeting. Additionally, the bill clarifies the board would not be allowed to discuss those materials unless it has complied with posting requirements. So I just want to let you know that we are supportive of the intent of this bill to make available any relevant materials for a notice meeting. However, the bill, as currently drafted, would create a number of logistical problems for staff and would prevent the board from discussing any legislative, regulatory, or budgetary materials that may become available in less than 72 hours. So for those reasons, we're recommending a neutral position if the bill is amended to address our concerns.
I would just like to make a couple of comments here. We on all of the bills we've recommended positions. Some are watched, some, as in this case, neutral if amended. I think there's one we would potentially oppose, but it's very early in the session, and these bills are likely to change. And also, none of these bills are apply specifically to our board. And I'm a little hesitant to wade into advocating our position on a bill when they're still being formulated and we don't have all of the information. We don't know what other stakeholders feel about these bills. So in this one, we've identified the concerns that there's what if first of all, closed session. Those you just want to clarify that this doesn't apply to closed session materials which aren't shared with the public and wouldn't be, so they should be excluded from this. And then things like legislation. If we're a committee like today, if a bill was amended yesterday and we're discussing that bill, this would essentially preclude us from discussing the amendments. And so I don't know if there's a way around that, but I just wanted to raise those concerns, and certainly we can share those with the author's office. But things, we may have more information by the time of the board meeting, but for right now, I don't know that I would want to take an official public position neutral if amended, or certainly if it was opposed. I don't want to oppose the bill without having all the information. So that's all. I'll turn it over.
But in the end, were you recommending a watch then, Mr. Palaio?
Well, this, yeah, I think for now, I didn't want to, I want to give the board members guidance on what the concerns are, but on all of these, at this point, well, and we can't take a position until after the board meeting, and these are likely to change at that point. So to the extent that if you agree with our concerns and if nothing changes, then our recommendation to the board would be to take a neutral if amended position. And I can, even without an official position, I can contact the author's office and share the staff concerns. And because these are relatively minor concerns. We're not opposed to the transparency that this bill is trying to achieve, and providing information in enough time so that people have a chance to review it. That's, those are things that we're supportive of. But it does, when we're dealing with all sorts of deadlines, it makes it difficult to conduct a meeting. Some things we don't have the information until right before the meeting. So if we're not able to discuss something that wasn't disseminated 72 hours in advance, then it may make the meeting moot. So yeah, I don't quite know how to articulate that. But for right now, these are our concerns. But I would like to continue to watch these bills and determine whether we need to weigh in and whether our position will be the same. Because a lot of these seem like they're more conceptual, and so they likely will be amended as the session moves on. Some of these bills hadn't even, at the time we put these materials together, hadn't even been heard in their first policy committee. So there's, they may not get out of that committee. There likely will be comments from other stakeholders that may be relevant. So just wanted to make this committee aware of those elements.
Yeah, no problem. So I have a couple questions, but before I do, I want to ask Mr. Sweet if he can, if he has any questions or concerns about this particular bill and whether or not we should take a position.
No, I think my only question on it is if we know what the likelihood of it being amended is. I mean, I guess that's the real question, right?
I would imagine this is something that's going to impact all state agencies. of all sizes. And so I would imagine that if we have these concerns, and we're a small program, other larger programs may have even more concerns. I would be surprised if this wasn't amended as it moves through, because there are going to be, logistical issues for all departments that have meetings. And so as much as we want to be transparent and comply with the spirit of this bill, it's already difficult with the the meeting notification timelines. We have to notice the meetings 10 days in advance, and and coordinating schedules and stuff. And then if we have restrictions on what we can discuss, if it wasn't disseminated 72 hours in advance, sometimes we don't have information like for a board meeting as far as our fund condition, and we may be waiting on information from the department's budget office that they're still compiling. So if we don't have that information 72 hours in advance, then we can't discuss the fund condition or our budget using relevant information. We'd be using information that was older and may have changed. And so it would put us in a situation of potentially having to not discuss an agenda item because the information changed before the meeting. And not that we were withholding information we already had, but if new information becomes available, we wouldn't be able to discuss it. So sorry, that was a long answer to your question, but yeah, I think it will get amended, because I can't imagine we're the only ones with concerns such as that.
Sounds like that would be the fact, yeah.
This is Andrea. I also would like to note that this bill has been reintroduced. So this bill, there has been prior legislation regarding the same issue, and there have been various bills on the floor in the past, and they have been amended. But however, they did not move out of their policy committees at the time. But I would assume that it would be very likely that this bill would be going in the same direction.
Yeah, it's going to have a lot of hurdles. It's going to create problems for. So I don't want to assume that it won't make it through the legislative process, but it might not. And if it does, it's likely going to need some amendments to address concerns.
Anything else, Mr. Sweet?
That's all for me.
Okay, thank you. I have a quick question and a comment. So I know that staff, Andrea, under fiscal impact, you say that this bill will not have a fiscal impact upon the board. And I just wanted to, can you elaborate on that? I mean, if we were to, do we have the staff, and this may be a question for Mr. Pulido, if we were to adhere to this today, do we have the staff? Would that create a workload issue at all, or can you comment on that real quick?
Not necessarily, because we would just have to, whatever information or documents we have available at that 72-hour point, that's what we would be able to share. Usually it's more than 72 hours when we post the information, because we, at the same time that we provide board meeting or committee meeting materials to board members, we post that information on our website. And so usually that's about a week in advance that, or at least a week in advance, that we send out the information. So the only thing this would do is prevent us from updating that material, providing board members or the public with new material after 72 hours prior to the meeting. And so it wouldn't create the only possible, it's kind of a stretch, but the only possible fiscal impact it would have if we had something we were going to discuss, but then we received information that changed the discussion, and so then we wouldn't be able to fully discuss the matter and would have to carry it over to another meeting. But I don't see any significant impact that this would have on us. It would just kind of tie our hands.
Yep, no problem. The other question, and this also for Mr. Sweet, this bill, to the question, this bill and I think it was Andrea said it, that it's very similar to AB 2028 from the 2020 legislative session. I don't recall if we took a position on 2020, even though, there was a lot of changes made during that legislative cycle to AB 2028. Did our board took a position? Do you recall, Robert?
And no, we didn't weigh in on that bill last year.
Okay. All right. So then, with that said, I like your idea, Robert, to watch this bill, and it's premature today because it will get changed. There's going to be several changes perhaps made, and so watching it, I think it might be the best route. So the recommendation that this committee would make to the board would be to watch it. Mr. Sweet, do you have any preference versus neutral if amended, or watch it?
Given the likelihood that it's to be amended, I would say watching it is fine.
And just for your information, what we'll do when we prepare these materials for the board meeting, we'll update this. We'll leave the staff recommendation, and then we'll have the committee recommendation. So the staff recommendation will reflect our concerns, and then because of the reasons we discussed, the committee's recommendation will be to watch. And then if we have new information to consider at the time of the board meeting, then the board would take the final position on the bill.
Okay, so with that said, then, before I call for public comments, we're going to go ahead and make a motion that the committee recommends a watch position on AB 29.
I'll second the motion.
Okay, so now I'm going to ask the moderator to please open the queue for public comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment on AB 29, please click on the Q&A icon on your screen, type "I would like to make a comment" into the text field, and submit that to all panelists. And seeing no requests, would you like me to close the panel?
Yes,
It is closed.
thank you. Thank you, moderator. So back on the motion. Mr. Sweet
Aye.
and Frank Rufino, aye. Moving right along to item number 7 on the agenda, and that is the discussion and possible action regarding AB 339, deals with state and local government open meetings. Andrea?
AB 339 has been authored by Assemblymember Lee and sponsored by the Leadership Council for Justice and Accountability. This bill is in the Assembly and has not been referred to a policy committee at this time. AB 339 would require all public meetings to have call-in or internet-based service options that provide closed captioning to the public. This bill would also expand language access, requiring translation services for the 10 most spoken languages in California. Basically, in essence, this bill would promote public participation in state meetings. Currently, the cost of providing increased access through technology and providing translation services is unknown. However, it is likely that we would see an increase in workload and operating costs as a result of this bill. The author has indicated there will be amendments to the bill, and right now staff recommends watching this bill and taking a position after it has been amended.
Okay, Mr. Puglia, go ahead, sir.
Yeah. I just wanted to, in light of the fact that the author's office has said that this will be amended. There's, all we can do is wait and see what those amendments are. But it does raise concerns that will be the same concerns for all of DCA's boards and bureaus. And so I don't know if the department will be looking at a universal solution if this bill were enacted. If the department would have a large or mass contract with a translation service that would be able to provide this for all boards and bureaus at a manageable cost. So there's a lot of questions that we don't have answers to, and plus the bill is likely to be amended. So there's not much we can do other than watch at this point.
Great, thank you, Mr. Palacio. Mr. Sweet, any questions or concerns with either this particular bill or the staff recommendation?
No, I think Mr. Pillay addressed the question that I had in my mind, which is whether we have this capability currently or not. And it sounds like we do not, but we're hopeful that if this was put in place, that we would be provided with the resources to comply.
Yeah, I would love to be able to do that. I mean, I'm very supportive of what this bill attempts to do, but just we have very limited means, and as we all know, our budget is very strained right now. So if the cost was prohibitive, I don't know how we would have to raise fees to be able to do this. So it's just something that we need to get all of that information before we can make an informed decision.
Okay, then with that said, I move that we recommend to the full board a watch position on AB 339.
Second the motion.
All right, before we take a vote, moderator, would you please open the queue for any public comments?
This is the moderator. We have opened the Q&A panel. If you would like to make a public comment on AB 339, please click on the Q&A icon on your screen. Type "I would like to make a comment" into the Ask field and submit that to all panelists. Seeing no request for comment, would you like me to close the panel?
Yes, please.
It is closed.
Okay, so we are moving into next bill, which is
Do we still
AB
need
646 by Assemblymember Lowe, and that's deals with expunged conviction. Andrea?
Do we need to take a vote on that last one before we move on?
Oh, I'm sorry, I missed that. Thank you. See? All right, scratch everything. Go back to the initial motion to take a watch position on AB 339. Mr. Sweet?
Aye.
Rufino, aye. Motion carries. All right. Now we are back to our next item, AB 646. Andrea?
AB 646 has been authored by Assemblymember Lowe. This bill passed out of the Assembly Business Professionals Committee and is now in appropriations pending hearing. This bill would require a Dca board to post information on their website about a revoked license, to update or remove that information within 90 days of receiving an expungement order related to a criminal conviction. This bill has been introduced in response to the legislature initiative to reform the criminal justice system, and we're supportive of removing employment barriers to healthcare professionals looking to secure employment. However, it's not clear whether this bill would require the board to remove all references to disciplinary action related to a criminal conviction. And we're also concerned this bill may limit our ability to protect consumers if we're unable to provide a complete disciplinary history. So for those reasons, we recommend a watch position and would like to have more time to determine the actual impact stemming from this bill.
This is one where I anticipate a lot of comments and positions being submitted. They just haven't trickled in yet, because it's a philosophical question. On the one hand, we don't want to impede a person who's been rehabilitated from being able to enter a profession and make a living, but we have a consumer protection mandate, and part of that is part of how we accomplish that is by educating consumers and making information available. So a consumer who takes the time to investigate or just research a health provider before going to them, they look on our website, and if it doesn't show any information about the fact that this person had a criminal conviction in their past, then that's information that they might have wanted to consider when deciding on a health practitioner. And ultimately, that's the decision that the legislature and the governor have to make. It will whatever the law is, we will abide by. So if we're able to provide information, then certainly we will. But if we're instructed or the law tells us not to provide certain information, we would remove reference to that on our website. The concern I have is that it's not just in a place that the information appears. We have documents that are now public, such as accusations, disciplinary orders that are posted on the website. Would we be required to remove those? And then also we post information and other areas of the website, all disciplinary action taken. We have a list. So, we would have to mine our website for any information referring to that discipline, which is probably doable, but it may be problematic. So I would like to have the benefit of knowing what other boards think about this, and consumer organizations before we take a final position. But I do have concerns. I anticipate this will be amended. There will be a lot of feedback and likely amendments on this.
Okay, thank you, Mr. Puleo and Andrea. Mr. Sweet, sorry. Any?
I don't have any questions or comments at the moment.
Okay. Do you have a suggestion for a motion, or?
I can suggest a motion. Yes, let's make a motion to watch AB 646.
Okay, and I'll second that motion. And before we vote, I'm going to ask the moderator to please open the queue for public comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment on AB 646, please click on the Q&A icon on your screen, type "I would like to make a comment" into the Ask field, and submit that to all panelists. Seeing no requests, would you like me to close the panel?
Yes, please.
It is closed.
Thank you. Back on the original motion for a watch position on AB 646, Mr. Sweet.
Aye.
Rufino, aye. Motion carries. And we are moving into our next bill, which is AB 1236 by Assemblymember Ting, data collection. Andrea?
So AB 1236 has been authored by Assemblymember Ting and sponsored by San Francisco's Jewish Vocational Services. This bill is in the Assembly Business and Professions Committee and will be heard on April 27th. This bill would require all healing arts programs to collect licensed fee demographic data and post that information on their website. Aggregate information collected would be reported to the Office of Statewide Health Planning Development. We're supportive of efforts to provide demographic information to consumers so they can make informed decisions when selecting a health provider. However, we would need more time to determine the fiscal and workload impacts and whether there are any efficient or cost-effective methods of collecting and reporting licensee demographic data. So we would recommend a watch position on this bill for now.
Thank you, Andrea. Any comments from Mr. Palaio?
Yeah, just that this raises all sorts of questions. Again, it's a laudable effort, but we, right now we're transitioning into an automated system which may facilitate gathering this information, but still we're likely going to have to promulgate regulations, which, as we know, we have a lot already that we're working on. And we'll have to change forms. We still have paper forms that would have to be modified, as well as electronic forms. It's not clear when we would have to be in compliance with this, and also whether it would be mandatory or voluntary on the part of licensees. If it's mandatory, then there would be increased enforcement if we have to discipline somebody who refuses or doesn't comply. So it just there's a lot of questions. Again, I would like to be able to see what other stakeholders feel about this, and if I don't know if the department has any ideas or suggestions. I'm sure they're still vetting this, and but if they think this is possible to do, because this would impact all of the boards and bureaus. So there's a lot of things that we need to research, and I'd like to let this unfold a little before we take a final position. But obviously we have concerns.
Okay, thank you, Mr. Palaio. Mr. Sweet.
No comments or questions at this time.
Okay, I just have a quick question, and I know it's going to be difficult to answer. Again, under fiscal impact, it says that it cannot be absorbed with the existing resources. So that implies that you're going to need additional staff. Is that too difficult at this point to determine whether that be a full-time employee or half-a-time employee, or could I'm just wanted your thoughts on that.
Well, yeah, and that's something that we have no way of knowing at this point. We may need to hire just a limited term person to help us promulgate the regs and modify the forms, and just the extra workload with setting this up, and then after that, there may not be ongoing significant workload that we'd have to worry about. But also, there's going to be IT costs. There's there may be an initial cost that we right now we don't have the resources to absorb. So we're kind of just guessing at this point, but I'm anticipating that there will be significant fiscal impact to this. So we just need more time to sort all that out. I think the bill does need to will definitely need to be amended to clarify a lot of these things. So as that happens, some of our concerns may be addressed, right? Because I don't typically, for DCA boards, we're special funded, and there's no general fund or outside funds that are made available to us to implement these kind of things. And right now for our board, we have such limited resources that we really can't absorb anything. And I'm not aware of any way that we could do this inexpensively. There's going to be definitely initial costs and perhaps ongoing costs. So.
Okay, thank you, Mr. Palaio. Mr. Sweet, you want to
make a motion to adopt the watch position for AB 1236?
I'll second that motion. And before we vote, Moderator, please check the queue for any public comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment on AB 1236, please click on the Q&A icon on your screen and type "I would like to make a comment" into the text field, and then submit that to all panelists. And seeing no requests, would you like me to close the panel?
Yes, please.
It is closed.
Great. Back to the original motion to take a watch position on AB 1236. Mr. Sweet.
Aye.
Rufino, aye. Motion carries. And we are moving into AB 1386, which is military partners and spouses, license fees. Andrea.
AB 1386 has been authored by Assemblymember Cunningham. This bill is in the Assembly Business and Professions Committee and will be heard today, actually. This bill would require a DCA board to waive license fees for military spouses or partners. Specifically, this bill would prohibit the board from charging an initial or original license fee to an applicant who meets expedited licensing requirements. We anticipate a revenue loss for the board, and that would be about $2,785 annually. We currently recommend a watch position on this bill because the current language is unclear as to whether this bill would require the board to waive all fees associated with obtaining a license. And that's all for me.
Okay, Mr. Pulio, do you have any quick comments?
No, I agree. I'm not sure because we have two fees. We have the application fee and then the initial license fee. And it appears that they want to waive all the fees for the military spouses that would be subject to this bill. And admittedly, the cost isn't huge to our board. I wouldn't want to oppose it just because of a $2,700 fiscal impact. We don't get a lot of these requests, but cumulatively these things add up. We have a lot of legislative mandates that we have to comply with each year. And keep saying it, we have an already strained budget. We don't have any money to spare. So we have to be cognizant of the fact that these costs add up, and without raising fees or unless there's some kind of resources made available to implement these things, it's difficult. And these are costs that would have to be subsidized by other licensees. So what this is essentially asking is the general population of chiropractors to cover the cost of license fees for these individuals. And so that's a question for the board to consider, because that's where our money comes from. But it's too soon to tell. And this, again, all these bills, it's so early. I wouldn't want to go out and oppose a bill like this without giving time to vet some of our concerns and see what changes might be coming. That's
Mr.
all.
Sweet?
Yeah, nothing. As Mr. Puleo said, I can't imagine that we would oppose this, but I'm fine watching it for the time being.
Okay. I just got a quick comment, Robert. Obviously, from what you said, we don't know which fees, but he says any and all fees associated. So that would include even what they call the pass-through fees, right?
Yeah,
if the Department of Justice says to.
Yeah,
the Department of Justice says
things like that. We don't. That's something that we don't have control over. So then, I don't imagine we would be required to pay the fingerprinting fee, which currently licensees or applicants pay. Do the live scan, but that's potentially a concern. And I would imagine at a minimum, they want to waive the application fee as well as the initial license fee. So, but it's not clear as to that. So there are some unknowns that would need to be clarified. And also, this is just something that we have to factor in because, so far we haven't received a lot of requests because we already, through previous legislation, we already expedite applications that are submitted by military and military spouses. And so on top of that, this would require us to waive the fees. And these things, they add up, and they need to be reflected in our license fees if we're going to be absorbing these things. So,
And I
just want the board
just,
to be aware.
yes, thank you. I think I know the answer, but just wanted you to confirm, because this bill is identical to AB 2631, which was from the 2020 legislative session. Did our board took a position in 2020 on AB 2631? I don't think we did, but I just
No, we
wanted
did
to.
not. Yeah,
We did not. Okay.
We
That's-
didn't have many board meetings last year, and they're bills that didn't directly and specifically impact our board. Because resources were spread so thin, we just we didn't take positions on legislation that we normally would have. But
Yep.
since
No
it's back,
problem. Okay, so then I move that we adopt the staff recommendation to watch AB 1386.
Second the motion.
Okay, the motion has been made and it's been second. Before we take a vote, let's go ahead and ask for public comments. Moderator, could you please open the queue?
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment on AB 1386, please click on the Q&A icon on your screen. Type, "I would like to make a comment" into the ask field and submit that to all panelists. Seeing no requests, would you like me to close the panel?
Yes, please.
It is closed.
Okay, so back on the motion for a watch position recommendation to the board on AB 1386. Mr. Sweet,
Aye.
Rufino, aye. Motion carries. So we're moving to the next piece of legislation, which is from also from Assemblymember Cunningham. It's AB 1468. Andrea.
AB 1468 has been authored by Assemblymember Cunningham and sponsored by California Physical Therapy Association. This bill is in the Assembly Health Committee and will be heard on April 20th. AB 1468 would prohibit a healthcare service or insurance plan that provides coverage for specified services, including chiropractic, from requiring authorization for the initial 12 treatment visits within a new episode of care. So in essence, this bill seeks to increase access to alternative treatment options, including chiropractic, physical, and occupational therapy, among other services. Staff is supportive of the sponsor's intent to remove barriers to needed services. However, this bill did not or has not allowed health and insurance plans to require a referral for, this bill allows health and insurance plans to require a referral for those services, and the primary provider would still need to justify denying the care. So we recommend a watch position as we would need more time to determine whether this bill would actually benefit chiropractic patients.
Yeah, right now, I mean, these things are complicated, and this is a managed care issue, and so it doesn't directly impact the board. Is one thing I want to make sure the committee is aware of. It potentially would be beneficial for chiropractors, but I'm not so sure about that because right now, chiropractic is a point of entry profession. A patient doesn't need a referral from a medical doctor to see a chiropractor, and I know many health insurers they cover chiropractic and don't require a referral. They allow 12 or 15 visits for chiropractic or acupuncture. So I'm not clear if this would even benefit chiropractors, and it could be problematic for chiropractors because it would some insurers may decide that they're just not going to cover chiropractic services if they are being forced to approve things without having discretion. So I don't know for sure that would be the case, but I am curious what health insurers see the impact of this bill and what their positions would be, as well as other professions. At this point I don't believe that CalChiro, they may have taken a position, but I'm not sure what their position is or if they've taken one. And so I would like to know their feelings about this. But I'm not really clear that this would even benefit patients because there's some ambiguity. So it's another one that we will continue to gather information, but I think we should watch it at this time.
Okay, thank you, Mr. Puglio. Mr. Sweet, any questions?
No, not at this time. It sounds like there are a lot of questions regarding this bill, so I don't have anything at this time.
Okay, just one quick question, Robert. Ms. Puglio, you may not know this, but as the association, the CCA, California Chiropractic, or the two professional association, have they taken a position on this bill?
No, not that I'm aware of. They haven't made us support. We'll reach out to them. I know. Given that this bill is sponsored by the Physical Therapy Association, I'm inclined to think that the other professions that are mentioned in this bill, there's physical therapy, occupational therapy, Asian medicine, chiropractic. So those, and I think also audiology professions. So there's a number of professions that on the surface, this sounds like something that would remove barriers to patients being able to see them. But, not being an expert on managed care, I'm not so sure that would be the case. And so I would like to know more. I'd like to know what position the health insurers take on this, and whether it would likely somehow negatively impact patients, because our main concern is the impact on consumers and patients. And so if it doesn't have a negative impact on the profession or on patients, I wouldn't be opposed to it. I don't know it's something the board would support. That we would have to identify a benefit to consumers or consumer protection aspect of this before I would recommend that the board support it. So there's just a lot of unanswered questions.
Yes, there is. Okay, so Mr. Sweet, you want to?
Sure, I make a motion to adopt the watch position for AB 1468.
And I'll second that motion. And before we vote, I'm going to ask the moderator to please open the queue for public comments.
This is the moderator. We have opened the Q&A panel. If you'd like to make a public comment on AB 1468, please click on the Q&A icon on your screen. Type "I would like to make a comment" into the text field and submit that to all panelists. Our first request for comment comes from Don Benton. Don, your line is open. You will have 3 minutes.
Hi, I just wanted to speak to this and let you guys know that we have been working with CPTA on the language to this bill, and our managed care committee and our GA committee have both been supportive. And we're currently recommending to our board a support position, not a high level, but a low level support position. And we haven't been concerned about any issues around requirements to, get referrals, but I'm going to actually take that back and look into that more.
Thank you, Don.
And seeing no additional requests, would you like me to close the panel?
Yes, please.
It is closed.
Okay, so back to the motion for a watch position on AB 1468. Mr. Sweet?
Aye.
Rufino, aye. Motion carries. And I think we are down to our last bill. SB 77, oh, no, yes, SB 772. Citations, minor violations. Andrea,
SB 772 has been authored by Senator Ochoa Bo. This bill is currently in the Senate Business and Sessions Committee and will be heard on April 19th. This bill would prohibit the board from assessing a citation fee for minor violations, and it would possibly result in a loss of $25,000 annually for the board. We are concerned that this bill would have a negative impact on the board's funds, thereby limiting our ability to recover enforcement costs, which account for more than half of the board's budget. So therefore, we recommend an opposed position at this time.
Mr. Julio?
I'm curious to see what happens at the first committee hearing, but this raises major concerns for me. There's because we by definition, or by the intent of citations is to address minor violations. We don't issue citations for gross negligence or sexual misconduct or those type of things. They're for they're for minor violations. So this potentially would impede our ability to issue any fines with a citation, and also it doesn't take into consideration how individual boards handle things. We take a progressive approach to discipline. We oftentimes for an insignificant minor violation, we would issue a letter of admonishment, or if in the course of investigating we find out that the licensee acknowledges the problem and they take steps to correct it and provide us with evidence that they've changed their procedures so it doesn't happen again, then we may not take any discipline. We may close it with a subject educated or something to that effect, because we're not looking to penalize, we're looking to correct problematic violations by licensees. So this is taking a one-size-fits-all approach and interfering with our ability to address these matters as we see appropriate. My big concern too is that if this bill goes into effect and we do issue a violation and we think it's appropriate, this is probably going to licensees or respondents and their attorneys will likely challenge any fine that we issue based on this bill, and then we would have to defend our decision that we believe this exceeded the minor violation threshold, and that's why we issued a fine. So then we're going to have to defend ourselves more. The things are going to go to hearing. We'll have to pay for Attorney General and Office of Administrative Hearing fees to defend these decisions to issue a fine. So I see this beyond the fine revenue that we would lose. It may also cost us money, and that's incalculable at this time what that amount would be, that the cost. So I curious to see, if other stakeholders weigh in. Right now, we don't know if there's other support and opposition out there. I would imagine that all or the majority of DCA's boards would have major concerns with this. And so I hopefully before the board meeting we'll have more answers. But I'm leaning towards opposing this bill.
Thank you, Mr. Vallejo. Mr. Sweet, do you have any questions or comments?
Yeah, I mean, I think we would want to retain the right to assess a fine for minor violations if possible or if necessary. I was curious to know what the if there's like a range of what typical fines for minor violations amount to.
That's a good question, and the law, the Business and Professions Code, gives us authority to issue fines up to five. No, I'm trying to blank here. Yeah, $5,000. Yeah. So I'm sorry. So we can go up to 5,000. We rarely go up that. That would be something that's on the more egregious end. I mean, for a minor violation, first offense, as I said, oftentimes we would, issue a letter of admonishment or something less than a citation. If we do issue a citation for the first offense, and if it's particularly if it's not very egregious, we would maybe issue $100, $500 for that violation, and then if it's repeated, then we would. If we issued another citation, we would elevate that. It's not very often that we we assess the maximum fine. So it's kind of on a case-by-case basis. We don't have a chart that says for this, you issue this. We have to look at the whole picture, the nature of the violation, whether there's a pattern of this behavior, and, cooperation by the respondent, and, if they take steps to address the violation or concerns so it doesn't happen again. We take all that into consideration when assessing a fine. So this would tie our hands in a lot of cases and take away our discretion to issue an appropriate penalty for the violation.
Yeah, and so I mean, based on what I hear you saying, if most of the fines are, especially the initial fines, are $100 or something in that range, and rarely go up into the $5,000 range. I'm just looking at the arguments, the pros to this bill, and saying that this would be integral to an economic recovery and providing financial relief. And it doesn't sound like this would be particularly impactful for economic recovery if those are the level of the fines that we're talking about.
Yeah, I mean, I don't, I imagine for some professions, any fine might be prohibitive, and but for this profession, especially given that we aren't outrageous or arbitrary in the fines that we issue. It's certainly the fine is more cost effective than us filing an accusation and the licensee potentially having to hire an attorney and defend themselves at a hearing. And if in some cases, if we're debating between should we, take the formal disciplinary, accusation route or issue a citation, we may err on the side of filing the accusation because of the concerns that are raised by this bill, and that would be more of a financial impact to the profession, to the licensees. So there's a lot that needs to be taken into consideration when you're trying to address this type of thing. I understand the senator's concerns and wanting to ensure that boards aren't abusing their authority, but I'm not aware of any examples of us abusing our authority. And if those things were called to our attention, we would defend ourselves, address them. But it hasn't been an issue. And so if it is an issue with certain professions and certain boards, then maybe the bill needs to be more specific towards those.
That's all I have.
Thank you. Thank you, Mr. Sweet. And Robert, I think you hit the head right on the nail that this bill would obviously prevent the board, from exercising its own judgment as to the appropriate penalty and potentially lose fees. But more importantly, and in my view, this bill would interfere with the board's ability to protect the health and safety and welfare of the public by taking that out. So I'm definitely sharing with you, your concerns. I think the intent may be noble, but it is written, it is just doing more damage to what we are charged to do, and that is the protection of the public. With that said, I will move that the committee recommends and oppose on SB 772 to the full board.
Second that motion.
Thank you, Mr. Sweet. So we have a motion. Before we take a vote, I'm going to call on the moderator to ask for public comments, please.
This is the moderator. I've opened the Q&A panel. If you'd like to make a public comment on SB 772, please click on the Q&A icon on your screen, type "I would like to make a comment" into the text field, and submit that to all panelists. Seeing no requests for comment, would you like me to close the panel?
Yes, please.
It is closed.
Thank you, moderator. Okay, that brings us to item number 13, which is future agenda items. And I want to start off by
Can we
having,
just take a vote on that last one?
oh gosh, yes. Thank you, Mr. Sweet.
Sure.
Back to the, it must have been almost 5 o'clock. Oh no, well, it is late. Back to the SB 772, back to the original motion to oppose. SB 772, Mr. Sweet.
Aye.
Rufino, aye. Motion carries. Okay, so now let's move to future agenda items. And as I mentioned earlier, I wanted to also for us to look AB 885, which deals with, it's part of the Beverly Keene Open Meeting Act, but it deals specifically with teleconferencing. So I want to add that for us to look at it. Any future agenda items from you, Mr. Sweet?
No, not at this time.
Okay. Any other comments from staff before I need a personal, I'm going to take a moment of personal privilege. I don't know if the chair gets it, but. So hearing none, then I'm going to take a moment. I'm going to call it personal privilege, but perhaps first and foremost, I wanted to welcome to our committee and to our board, Mr. Sweet. We only have 2 public members on this board. And so I've been carrying that flag for a little while, and I'm really happy to see another public member to join the board and to join the team. So welcome, Mr. Sweet. And secondly, before we adjourn, I would like to thank our staff, Andrea, our committee staff, for preparing those very long and worth analysis. I'd like to thank Mr. Palaio for always leading us, and I'd like to thank Mr. Knutz for providing excellent legal services. So thank you all for making our committee meeting successful. With that said, unless there's anything else, do I need to call for any more public comments? I believe I don't need to, right? Or do I need to call public comments one last time? I think I have to do it one last time, right, Robert?
I don't know, because we did.
For future agenda items?
Yeah, so Michael, can you guide us on that? It's not on the agenda. We moved that to the beginning of the meeting, so I don't imagine we have to do it
Okay.
again. So probably
All
just
right.
go to future agenda items.
Sounds good. Well, that then concludes. I need a motion to adjourn.
I'll make a motion to adjourn the meeting.
I second that motion. You all have a great evening, and we'll be seeing you soon at our next board meeting.
Thank you, everyone.
Thank you very much, everyone. Appreciate it, Mr. Rufino. Thank you for the welcome.
Of course. Have a good evening, everybody. Take care.
You too. Thank you. Bye.